Well, good morning, everyone. I want to start by welcoming our witness, Dr. Michal Friedhoff, the Assistant Administrator for the Office of Chemical Safety and Pollution Prevention. Michal, as most of you, is no stranger to EPW or to the issues that we're going to be discussing today. Having worked on this committee with us for a number of years, and also previously for Senator Markey, although he says he worked for her in both the House and the Senate. 2016, Michal was one of the lead negotiators of the Lautenberg Chemical Safety for the 21st Century Act, the first reform to the Toxic Substance Control Act, or TSCA, in approximately 40 years. A number of us worked tirelessly alongside our staff, our colleagues, often on and off this committee to support the bipartisan reforms in the Lautenberg Act. These reforms would help ensure that TSCA worked as Congress intended to protect the health and safety of Americans and our environment, while also allowing for innovation and competition within industry. The task of protecting the health of our families, our communities, and environment, while also continuing to advance chemistry that enriches our lives, is no easy feat. And it takes skill and experience to navigate the complexities around the implementation of this law. Through TSCA, Congress has charged the EPA with this demanding responsibility. Since we last welcomed Dr. Friedhoff before the committee in 2022, I want to share some of the progress that's occurred in relation to the implementation of TSCA. The first 10 priority chemical reviews that were established in 2016 have been completed, and the Biden administration has already begun to publish proposed rules for these chemicals, some of which are known carcinogens. The EPA has also launched several initiatives to prioritize and streamline new chemical review for chemicals associated with batteries, with clean energy technologies, and with semiconductors to more quickly deploy investments from the Bipartisan Infrastructure Law and the Inflation Reduction Act, major pieces of which were negotiated and discussed and debated right here in this room. According to the EPA, since June 2023, the agency has more than doubled the average amount of new chemical reviews that they are able to complete each month. This means EPA is addressing the backlog of chemicals awaiting review while also reviewing new submissions. But as the members of this committee have often heard me say, everything I do, I know I can do better. And the same is true with respect to TSCA. And as we gather here today, my hope is that this hearing will offer us an opportunity to reflect on and discuss what is working better and what can be done further to improve the implementation of this critical law. Well, let's be clear. There's still more work to be done. The EPA needs adequate support from both Congress and the administration to meet the expectations set into law by those of us who helped write the Lautenberg Act. As Dr. Friedhoff will highlight in her testimony, the EPA has been tasked with high expectations and a heavy workload, but has not always been equipped with necessary funding to complete this technical work. Congress needs to ensure that EPA has the appropriate resources to implement TSCA as intended. Further, we know that the EPA is updating its fees rule to be able to more effectively collect revenues from chemical manufacturers. This is an important part of the funding equation, and we look forward to hearing from Dr. Friedhoff more about this effort. Insufficient resources over the course of multiple fiscal years have led the agency to miss deadlines and to delay decisions. This situation has created grievances from both those in industry pushing to get their chemicals to market and from environmental advocates eager to see harmful chemicals regulated. As Dr. Friedhoff will relay today, the EPA is implementing the law that is written to the best of their ability. That said, we hope that today's discussion will help us determine what further actions EPA can take or what additional resources Congress can provide to better resource the Lautenberg Act's implementation. In closing, let me just reiterate a couple of things, if I could. First, the committee working together with Senator Capito and all the members of this committee to ensure that we're providing the agency with the resources it needs in fiscal year 2024. Second, we'll continue to collaborate with the EPA and request transparency in the agency's actions with EPA and request transparency in the agency's actions as they work to protect us from harmful toxins while allowing chemistry to usher in a new world of clean energy and life-saving technologies. Dr. Friedoff, we look forward to hearing from you today, and welcome back. And with that, let me turn to our ranking member, Senator Capito, for her opening remarks. Senator Capito.
Thank you, Chairman Carper, and thanks for holding the hearing. And Dr. Friedoff, thank you for being here. Thank you for coming to my office last week. I think we had a very fruitful discussion and very substantive, so I appreciate that. For 3 years, the Biden administration has been implementing the 2016 TSCA amendments, and yet the slow pace, and the chairman talked about this, of new chemical approvals has not improved. The scapegoat of blaming the prior administration is no longer holding water. This 3 years is long enough to take the reins. Reviews are regularly blowing past the deadlines by months, but in some cases years. Approving submissions within the deadline is not an aspirational goal. It is a legal obligation for the EPA to ensure that innovation is not stifled by bureaucracy. Agency timeliness in the chemical space is crucial to maintaining a competitiveness in the global market and also achieving what I believe a point of bipartisan agreement, expanding key industries and onshoring critical supply chains right here in this country. Chemical manufacturers in China are more than happy to fill the void of U.S.-based companies that are stuck in regulatory purgatory. Regulatory purgatory. That's a hard one to say together by the EPA. The slow pace of new chemical approvals forces continued reliance on older chemistries that may have not just lower performance, but higher risk profiles and fewer environmental benefits than newer alternatives. According to a 2022 survey of American chemical manufacturers, 70% reported that they have decided to introduce new chemicals and therefore make the requisite investments and job creation outside of the United States. Let me repeat that. They have decided to introduce their new chemicals outside of the United States. Slower reviews create a negative spiral for the EPA's own work. Slower reviews means fewer submissions, and with fewer submissions, the agency collects fewer fees to implement TSCA. In addition to the slow pace, a troubling zero-risk approach at the EPA has taken hold of the TSCA program. Since 2021, the number of cases that has received a determination of, quote, not likely to present risk has dropped by 75%. It seems that no volume of data provided by applicants is satisfactory to the EPA to drop its predisposed worst-case assumptions of risk. Previously, you stated that it is a submitter's responsibility to come in earlier to talk about the data that your assessors require. Those that have heeded that advice have not had positive things to report back. Shareholders or stakeholders have complained of a lack of responsiveness from the EPA staff, moving of goalposts, and presumptions of denial at the start of the process, as well as a failure of the EPA to consider data and approvals from regulators in Europe and Asia. In short, they found no benefit from making contact with the EPA early and often. Your office seems to also have a mission creep where no data can satisfy risk assessments, and the EPA is intruding on other agencies like OSHA, to which Congress has provided relevant authorities. The zero-risk approach undermines the intent of the 2016 amendments and, ironically, will hamstring the Biden administration's ability to realize its own goals. As an example, in 2023, the EPA selected a company to receive a Green Chemistry Challenge award for developing a new bio-based chemical feedstock that would significantly decarbonize the chemical industry. Meanwhile, when that same chemistry went through the TSCA review process, it received such stringent restrictions that it can no longer be commercialized. Unfortunately, this is just one of the many examples of the profound disconnect between the new hazard-based interpretation of TSCA and the Biden administration's so-called onshoring efforts. It is the same disconnect that the EPA has the EPA mulling proposed rules to destroy domestic semiconductor manufacturing by effectively prohibiting essential chemistries, despite Congress and the Biden administration doling out tens of billions of dollars to stand up capacity here. I fear the program is in a worse state now, maybe, than before the Lautenberg Act was passed. We may not agree on everything, but we can at least agree that the status quo needs to change. It is not lost on me that you didn't receive all the resources that you would like. However, simply throwing more money at the problem while doing nothing to change the underlying structural issues is not a solution, and Congress has made more resources available. The EPA hired almost 2,000 new employees last year, but somehow the TSCA program struggles to fill vacancies that have been open for years. It is concerning to me to hear, and we talked about this last week, that it has taken 2 years to hire a single person under the Title 42 authority that Congress provided in 2022. It is also troubling that the Office of Inspector General criticized the OCSPP for its lack of standard operating procedures and outdated guidance to more effectively onboard new staffs. If resources are a problem, then why at a time when 70% of guidance documents and standard operating procedures for the new chemical programs are out of date, is the EPA announcing that it is expanding resources for elective programs without statutory authorization? Examples like this give me the impression that TSCA's program's resource demands and programmatic workload arbitrarily grow every year, no matter what resources Congress makes available or the policies that we choose to prioritize. So during today's hearings, I expect we will once again hear about the need for more resources, and we will consider that request as the Chairman mentioned. But more valuable will be learning how you intend to allocate the resources you have and what transparent commitments you're willing to make to improve management of and tangibly accelerate the review process. I shared with you in advance some of the ideas that we have to achieve that goal together, and I hope that we can discuss those this morning. Thank you, Chairman Carper.
Thank you so much. We're now going to turn to our witness, and we're pleased to welcome you back to our committee today. Dr. Michal Friedhoff is the Assistant Administrator of the Office of Chemical Safety and Pollution Prevention at the Environmental Protection Agency. Dr. Friedhoff has more than 20 years of government experience and service, the majority of which were spent on Capitol Hill, and many of which were spent literally in this building. She began her congressional service in 1996, as I mentioned earlier, in the office of then Congressman Ed Markey as a Congressional Science and Engineering Fellow after earning a PhD in physical chemistry at the University of Rochester. With environmental expertise spanning a range of policy areas, her legislative work includes the 2016 reauthorizing of the Toxic Substance Control Act, 2019 legislation to address PFAS contamination, the fuel economy provisions in the 2007 Energy Independence and Security Act, and a law requiring the creation of an online database of potential consumer product safety defects. Before you begin your testimony, Dr. Friedhoff, I've had a number of people who said to me, I've never met anybody named Michal. Where does that name come from? And for those of you who are steeped in the scripture, you may remember the story of David and Bathsheba. And they had a son who sadly died. And he ended up having other wives, one of whom was named Michal. And Michal became the mother of a baby named Jedediah. Who is Jedediah? Jedediah became King Solomon, one of the wisest men who ever lived. And this is a new generation of Michal, but she has quite a history in her lineage. And we welcome you warmly back to a committee where you've spent so many years. Please proceed. Thank you.
Good morning, Chairman Carper, Ranking Member Capito, and other members of the committee. And thank you for the invitation to testify about the Toxic Substances Control Act. It's always a pleasure to come back to EPW. When I was last here, I described how years of underfunding had delayed our work to put essential protections in place for communities across our country and delayed our ability to review the new chemistries needed to power our economy. And while those problems haven't entirely been solved and won't be at current funding levels, I'm proud to say we have come a long way. The promise of the new law was for EPA to evaluate tens of thousands of existing chemicals left unreviewed under the old law and to write rules to protect people. and we're finally starting to make good on that promise. We propose rules for 5 dangerous chemicals that would collectively protect 1 million workers and 15 million consumers. And we feel a strong sense of urgency to get these and another 4 rules we have yet to propose across the finish line. I can also assure you that I have personally met with companies who think our proposals miss the mark for some uses. We're taking their input seriously, and we'll be making some needed adjustments along the way. We're also working on our risk evaluations. We've released 2 drafts and expect to finalize 7 this year. Last month, we announced the next 5 chemicals we expect to evaluate, including vinyl chloride, a cancer-causing chemical that was one of the examples used by the Nixon administration when they first came to Congress and asked Congress to write the original TSCA. And before we even named those chemicals, for the very first time, we also asked a very wide range of stakeholders for their input and their data so that we can get a jump start on those risk evaluations and come closer to meeting our deadlines. We're expanding our scientific toolbox for risk evaluations with approaches that focus on the most concerning exposures, efforts to improve our understanding of occupational safety practices, and ways to account for exposures to the most vulnerable populations. These changes will help ensure that the people who need chemical safety protections get them and get them faster. EPA also plays an important role in ensuring the safety of new chemicals. If the 2016 requirements that EPA formally evaluate the risks of all new chemicals before they were allowed into commerce had been the law all along, our PFAS pollution story, for example, might have had a very different ending. I know there are continuing concerns that we're not moving fast enough to get new chemistries to market, and I know there's more we can do. But I refuse to accept that we have to choose between safety and speed. With the budget increase, we hired 14 new chemical staff with 7 more hires in the works, which were much-needed reinforcements for a staff that had been stretched razor thin. We've standardized our review approaches for some of the chemicals used in batteries and semiconductors. We've developed a framework for new PFAS, which will ensure their continued availability for sectors like the semiconductor industry. And we've prioritized the review of the new chemicals we need to support the Biden-Harris administration's domestic manufacturing initiatives, and now review those in 1/3 of the time compared to other sectors. And by any objective standard, these efforts are working. In FY23, we completed 70% more risk assessments compared to FY22. Since June, we've more than doubled the monthly average number of completed risk assessments as compared to the year before, and we've cleared out about 50% of the older backlogged cases. But the truth is, we're not able to achieve all that TSCA was expected to. The problem's clear. TSCA's underfunded. It's the conclusion of EPA's analysis, the Inspector General, and GAO. And the solution's equally clear. We don't need to change the law. We need funding to implement the law we have. Full funding would mean 25 new hires to review new chemicals. It would mean we could modernize our IT more quickly, modernize our procedures in science more quickly, do more industry outreach, and come closer to meeting that 90-day deadline for reviewing new chemicals. Full funding would allow us to hire 75 new people to finish our risk evaluations and rules more quickly, which means that the protections workers and communities have been waiting for decades will also come more quickly. But no matter what our budget is, you have my assurance that we're going to continue to build the foundation for a chemical safety program that can deliver both the protections and the regulatory certainty that Congress envisioned in 2016. Industry and environmental organizations all know that our door's always open, and I hope you won't hesitate to ask for additional briefings, calls, or answers to your questions. And if an EPA visit to companies or communities in your home state would help, we'll do our best to make it happen. We all want the law to work as Congress intended, and I'm fully committed to doing whatever it takes to get there. Thank you again, and I look forward to your questions.
Thanks so much for your testimony and for being with us today. You have been consistent in your testimony to this committee that EPA has not had the adequate resources needed to fully implement the Lautenberg Act, and I think most of us would agree with that. Funding for the program can come from 2 different sources, as we know. user fees generated by EPA and annual appropriations provided by us. In FY 2023, EPA received some additional resources from Congress, as you know, though still well short of the President's request. The EPA is also working to improve its ability to collect user fees. Would you give us a sense of what the EPA was able to do with the increased funding in FY 2023? I know you've touched on this to some extent, but I think it could deserve some additional attention. And what more would the EPA be able to do if the agency received additional funding through both annual appropriations and more effective user fee collection?
Well, thanks very much for that question, Senator Carper. And we have really prioritized hiring with that additional pay increase or funding increase, and have especially focused our efforts on the new chemicals division, because we really do agree that that was the area that was most under-resourced as a result of the new law, which basically changed our, what our past practice had been, which was reviewing 20% of new chemicals before they go into commerce, to doing 100% of new chemicals before they go into commerce. So 5 times the amount of work, and for 6 years, 0 extra dollars with which to do it. So in addition to sort of to prioritizing hiring and getting people in the door and trained as quickly as possible, we've also really tried to standardize our approaches for chemistries that we know industry comes in with a lot of applications for. So, for example, we've been working to create a standardized and streamlined review process for the chemicals that are needed by the battery sector. We've got a years-long collaboration with the semiconductor sector, and that has resulted in a regulatory path forward for dozens of the photoacid generators that they need to do their work. And I personally met with them a couple weeks ago, and we talked about expanding that collaboration in the future. So we've really tried to work smarter, not harder, which is something Senator Markey often says, and are going to continue to do so with the funding that we have. If we got more, we'd be able to modernize those standard operating procedures more quickly. We'd be able to modernize our science policies more quickly. We'd be able to create efficient approaches for classes of chemistries more quickly. And of course, we'd also be able to write rules more quickly and do risk evaluations more quickly, which would move through the tens of thousands of chemicals that were left unreviewed under the old law more quickly as well.
All right, thank you. Before I turn to Senator Capito for her questions, I have one more I want to ask. In 2018, the previous administration, you'll recall, promulgated a user fee rule that was based on faulty data, which has limited the EPA's ability to collect user fees as intended by those of us who worked to pass the Lautenberg Act. The Biden administration has been working to update this data and revise the rule. Here's my question. Would you please explain to us where the previous rule went wrong, and how the Biden rule is proposing to correct it? And also, when do you anticipate the new rule will be finalized?
Sure. Thanks for that question, Senator Carper. So the Congress expected that EPA would write a fees rule to collect 25% of our authorized TSCA costs from fees. The first fees rule didn't collect any fees until fiscal year 2019, and it exempted the costs of the first 10 risk evaluations from being subject to fees at all. And those were by far the most expensive thing that the agency was working on in those first 4 years of the law. So as a result, we only collected a couple $1 million a year, $2 to $5 million a year in the first couple of years under the new law. And moreover, to calculate the 25% baseline, the previous administration used the costs of the old TSCA before it was revised to expand EPA's authority. So as a result, overall, that first fees rule collected less than half of the 25% of authorized TSCA costs that Congress expected it to collect. So we've done things differently. We have tried to heed congressional direction to reflect the accurate costs of implementing the law in our proposed fees rule. I think that rule's in the final stages of review at OMB, and I expect it to be finalized in the coming weeks.
All right, good, thanks. Senator Capito.
Thank you. I mentioned the document that we had shared earlier, or last week, and you all came back with some responses to that on ways that we could improve the system, and I wanted to get your initial reaction on any of these you think would help the most, and And so you're, maybe prioritize 1, 2, or something of that nature.
Sure. Well, thanks again for the constructive meeting we had, Senator Capito. I always appreciate the way you and your staff work with the agency, and that, since I've been there, and of course on the Hill as well when I was here. So I thought your list had a lot of really good ideas in it, and I think there's a few that I feel like we can commit to as long as our budget's not cut. So first, there was a program called the Sustainable Futures Initiative that existed before the law was changed, and the purpose of that program was for EPA to help industry write better new chemical submissions, so do training, technical assistance, and that sort of thing. So assuming our budget's not cut, we would like to hire someone whose entire job it will be to revamp the Sustainable Futures Initiative and build on the outreach to industry that we've been doing over the past few years to help them help us, really, in reviewing new chemicals. Another thing, that your list said, it said that sometimes we use models instead of industry submitted
Right.
data, and there's sort of an interest in getting more transparency from us on why we might choose to do that if we have actual industry data, and we think that's a great idea and are absolutely able to commit to that.
Okay. I'm going to stop you
Yeah.
there because I'll have an additional, on the resource issue, because this keeps coming up. And your budget has gone up. And I mentioned in my opening statement the interesting called Title 42, which seems to be the universal title that does everything. But it gave you an opportunity to get some highly specialized individuals. You've had this ability for 2 years and haven't used it. I mean, it's hard for me to square, I need more resources, when we gave, as a Congress, you an ability to really specialize here, and it hasn't been used. What kind of assurances is more resources going to solve this issue?
Totally appreciate the question. We're actually really excited about that authority, even though it seems like we
Because
haven't
you and
used
only
it.
one other person, one other
Right.
entity has this
So
ability.
it took us more than a year to kind of do the administrative things that we needed to do, both within the agency and with OPM, to get the all clear to actually use the authority. So we haven't had the clearance to use it for 2 full years. We do want to use it, and I think the very first place we would use it is in the new chemicals program, because having a senior scientist who can really help us modernize those processes would be great. I will also say, though, that those hires cost more money.
Right.
So when we're balancing, can we have 3 risk assessors or 1 senior scientist, we aren't quite comfortable yet to put our money on the senior scientist, but we're getting there.
Well, I mean, I would hope that authority, since it's so unusual and I think could be impactful, and having just on the face of it, having a senior scientist and then having younger, newer hires coming in, we would have a mutual benefit there as well. Let me ask you, one of the suggestions was sort of a mid-review meeting, mid-stage meetings between engineering team members and submitters. You were pretty negative about that when we talked earlier last week, but I do think, and I think some of the stakeholders feel that if they could see where they are before they get into the engineering phases and other more technical phases of the assessments, so they could make the adjustments mid-stage instead of waiting towards the end, what would your response be to something like, it seems to me that would benefit both sides of the submission?
So I did take that back to my staff. They do feel like it could have the unintended consequence of slowing not just that application down, but other people's applications down as well. We did have 2 other ideas that we think get to the same problem that you're raising. And the first is, we encourage companies to come in and have pre-submittal meetings with us. We don't always have engineers in those meetings, and we could. So I think that would be one way for companies to sort of get a reality check on what information they might want to include in their package before they even send their package to the agency. And the second thing that we're able to do now that we have some more staff is actually create a second queue, a different line for those applications that are almost at the end of the process, but something in the engineering changes and they need a little rework before they can get over the
Right.
finish line. So we actually want to create a dedicated a tiger team of people whose job it will be to get those applications over the finish line more quickly. And we actually think that might be a faster way of getting at the problem that
Yeah, I
you're
mean, I think
talking
that makes a
about.
lot of sense. The one thing I would say is, in talking with submitters ourselves about this mid-evaluation meeting, I think their opinion, sort of anecdotally would be, if I can get more clarity, more procedural clarity midway through the process, I'll take a longer process.
Yep.
Because in the end, it ends up being longer anyway. So I would just put that on your plate with everything else. And thank you, Mr. Chairman.
Thank you very much. Senator Bozeman, you are next. Welcome. Good morning.
Thank you, Madam, Mr. Chairman. Thank you for being here. We appreciate your many years of service in lots of different ways. Section 9 of TSCA requires EPA to consult and coordinate with other federal agencies on its TSCA activities for existing chemical reviews to maximize enforcement and reduce duplication. Long-standing executive orders also require interagency reviews of significant EPA actions. I guess the question is, why hasn't EPA sought feedback from other agencies like USDA, FDA, the Small Business Administration, or Department of Defense on its soon-to-be-released draft of the TSCA risk evaluation of formaldehyde?
Well, thanks very much for that question, Senator. We actually engage more across the executive branch than I think had previously been done. We have an interagency TSCA group that includes membership of DOD, the Ag Department, FDA. It meets almost monthly, every month or two, I think. And we do talk to them in a very proactive way about the work that we expect to be coming up. We talk to them about the chemicals that we've just put onto the TSCA process before those chemicals were named to the public. So we're actually doing a lot of very proactive engagement with the rest of the federal family, and we'll certainly be doing that when it comes time to release our draft formaldehyde risk assessment as well.
Well, I understand the problem of being underfunded. But also, I do think there's a lot of stovepiping. We should be working more interagency. Here's what the small business said in their file comments last month on your risk evaluation framework rule. Quote, EPA should commit to a robust interagency process for review of the draft and final risk evaluations. Quote, unfortunately, neither the preamble nor the current EPA practice reflect the commitment to interagency collaboration. EPA's risk evaluations, quote, create a significant risk that the resulting risk management regulations will impose unnecessary and duplicative burdens on small businesses with minimal public benefits, end quote. Quote, it is not good use of EPA's resources to duplicate the effort and expertise of these other federal offices, end quote.
I think we greatly value the input from other federal agencies that we get during both the risk evaluation process and the risk management process, which does go through formal interagency review. And we've been proactively reaching out to the agencies that we know use some of the chemicals that we're looking at to make sure that we account for critical uses and needs that they might continue to have. I think those conversations are going really well. I've personally been involved in many of them, and we do take that responsibility to talk to the other agencies extremely seriously.
I have the opportunity to serve also as ranking member on agriculture. Formaldehyde is something that many users use there to keep us safe and keep our food supply safe, keep it affordable. Pork farmers use formaldehyde to reduce virus infectivity in pigs, as a barn disinfectant, protect against African swine fever. Egg producers rely on formaldehyde during incubation to help protect hatching eggs against bacteria like salmonella, animal feed. Again, the list goes on and on. Is it true that the EPA is considering an existing chemical exposure level for formaldehyde, which is lower than the levels of formaldehyde humans exhale, and as much as 16 times below exposure levels set in European jurisdictions?
Well, first of all, let me just say that we have a great relationship with your staff on the Senate Ag Committee. Same with Senator Stabenow's staff. We view that relationship as extremely constructive and collaborative. I'd also note that the pesticidal uses of formaldehyde are not subject to TSCA. But getting to your question about the exposure limits, we haven't calculated a level like that for formaldehyde yet. It's something that we do at the end of our draft risk evaluation process, and so we haven't published one. But I can commit to you that if the risk evaluation and which by law is not supposed to consider costs and other non-risk factors like the ones you're raising, if we end up with a level like that in the draft risk evaluation that can't be measured because it's below background, we'll say right in the draft risk evaluation that it won't be the thing that we would propose to do in our rule. And we're not gonna propose something that can't be met if that's the way it turns out in our risk evaluation.
I would hope not. Thank you.
Senator Lautenberg, good to see you. Thanks so much. Senator Mullen, how are you?
Thank you. Good to see you.
Nice to see you.
Ma'am, thank you for being here. This committee has been focused on plastics for quite some time, and as I always like to say, almost a war on plastic. I want to be very careful as we're moving forward that the EPA is actually working with industry, not just working with activists and knowing where we're headed. And I do have some concerns because last month the EPA announced 5 more chemicals for prioritization underneath TSCA, all of which use plastics. The chemicals that they're using all goes towards plastics, including vinyl chloride, which is a chemical used for PVC piping. Obviously, that is something I'm very familiar with, and it raises alarms because, I mean, we use PVC piping in almost all your homes now, either through your drainage or your water. Most of our drinking water is delivered through PVC piping. And when we start looking at eliminating, there's a lot of questions to say, okay, well, what are you going to do then? And obviously, what are you going to replace it with? You were quoted recently in a press release. You chose to quote a partisan, what I would consider very partisan, radical anti-plastic activist and president of Beyond Plastic named Judith. I'll leave her last name out of it. In the article, Chairman, I'd like to enter into record from E&E News, December 14th, a quote that Dr. Friedhoff credited that meeting with Judith is making a real difference as we move forward to make these decisions. My question...
Without objection.
Thank you. My question, ma'am, is when you go on a victory lap with activists and include their quote directly under your press release, how does manufacturers, contractors who work in the industry have any confidence that this is not just an activist move driven by and prejudged before it even comes out?
Thanks for that question. I think that any of the stakeholders who work on TSCA, whether they're companies, whether they're families who have lost family members because of exposures to chemicals, environmental organizations, labor organizations, other federal agencies, there's not any of them who would say that they feel like me or my staff aren't accessible to them, don't listen to them,
Being
and
accessible is different.
aren't attempting to fairly implement the law.
I think being accessible is not the question here. When you quote an activist in your paper, when you're releasing information that you're going after plastics, and you're quoting a president of an activist group that's beyond plastics. And you didn't quote any industries in there. When you got a movement towards that to begin with, being accessible doesn't mean you're listening. Doesn't mean you're taking the industry into account or what is the next step for the industry. That a lot of people listen in Washington, D.C., but they already have their mind made up where they're headed. And when you quote someone like that, it would obviously send shockwaves to the industry saying that your mind is already made up before you even made this decision that you're looking into it. So I'm asking, how can they be confident that you're actually taking them into consideration?
First of all, I'd say we met with the industry to tell them what our short list of chemicals was before we met with any of the, with that particular organization. Second of all,
Why would you choose the need then to quote her?
I think there is an undeniable interest in a large part of the community in taking a look at the chemicals that are used to make plastic. Vinyl chloride was actually the example used by the Nixon administration in the 70s for why Congress should write a Toxic Substances Control Act in the first place. But I assure you, we've got a multi-year scientific process that precedes any regulatory decisions, and we haven't even started that process. We are committed to being fair.
When you say multi-year, what are you talking about? So
It'll
before your
be-
decision is coming out on anything, you're going to spend years studying this.
Correct.
So what does that look like?
So in the next year, what we're trying to do is work with federal agencies, industry, other organizations to get data and really sort of get ahead of our risk evaluation process so that we can meet our deadlines. After this year passes, the law gives us 3 to 3.5 years to actually finish the draft risk evaluation. There will be multiple public comment periods as well as a peer review of the draft risk evaluation during that time. So really, an enormous number of opportunities for companies to provide their perspective and give us their data. It's only after that that we would move to proposing a rule for vinyl chloride. And I can assure you with full confidence that nobody at the agency has made up has any idea of what that rule would look like. We've only just started.
Thank you. Thank you, Mr. Chairman.
Thanks for those questions. We've been rejoined by Senator Markey while he prepares to ask some questions. I want to quote, I don't think this is Richard Nixon, but one of my favorite quotes is, "People may not believe what we say, they will believe what we do." And I think that's something for us all to keep in mind. Thank you. Senator Markey, welcome.
Thank you. Thank
We must have a sense of deja vu here with
Just
our
a sense
witness.
of deja vu. Eleanor Roosevelt said, I do not see the things which have been done, but only those things which remain to be done, which I think fully reflects the philosophy of our witness here today, that there's more work to be done. And so, first of all, thank you to Dr. Friedhoff for your decades of work, including in my office, to protect the public from dangerous chemicals. As you know, I've fought for decades on behalf of the families in Woburn, Massachusetts. In Woburn, there was a boy named Jimmy Anderson. He was like any other kid from Woburn, except that at 3 years old, he was diagnosed with a rare form of leukemia. And the kids in his neighborhood were like kids anywhere around Boston, except that they were also being diagnosed with this rare form of leukemia at an alarming rate in his neighborhood. And because of their exposure to trichloroethylene, or TCE, these children fell sick and died, deaths that may have been prevented if we had laws in place that allowed us to ban the use of these chemicals to begin with. But finally, last October, you led the EPA in proposing to ban the use of TCE, an incredible accomplishment. That story became the book, A Civil Action, and then the movie, A Civil Action, about those families, and that book nominated for an Oscar. So, Dr. Friedhoff, did the 2016 TSCA amendments make it finally possible to take action against TCE?
Thanks, Senator. The answer is unequivocally yes. You know, when I I learned about the Anderson family from you, but it wasn't until I started working on the TCE rule at EPA that I realized that Jimmy would have been exactly my age if he hadn't died as a kid. He might have been sending his kids off to college. He might have had a life like mine. And it's not just his family. On the way to meet you that day when we announced that proposed rule, I phoned 2 other parents who lost children and let them know that we were finally going to be addressing the risks of TCE because Congress had finally given the authority to EPA to do that.
Yeah, and we were able to get it designated as a Superfund site, to get it cleaned up, and it is now the Jimmy Anderson Transportation Center, named after that boy who Ann Anderson had brought into my office when he was 9 years old, asking for help because we didn't even have a law at that time. We didn't have a Superfund law. Senator Mullen asked about the listing of vinyl chloride and what it means for companies. That's a fair question, and I'm glad Dr. Friedhoff noted those companies are part of this process. But I want to raise another group of stakeholders here. Next week will mark 1 year since a toxic train derailment and chemical fire devastated East Palestine, Ohio, and the surrounding community. Vinyl chloride was the main chemical being transported on that Norfolk Southern train, more than 887,000 pounds worth. So I was glad to see EPA's recent announcement that vinyl chloride is under consideration to be a high priority chemical for regulation under TSCA. So Dr. Friedhoff, would an eventual ban or use restriction of vinyl chloride help protect communities like East Palestine from hazards ranging from work exposure to disastrous explosions?
Thanks, Senator. You know, like I was saying to Senator Mullen, our risk evaluation and our rule on vinyl chloride has to go through a very rigorous scientific process. But the reason why the Nixon administration used vinyl chloride as one of the 3 examples of why Congress had to write this Toxic Substances Control Act was because they knew even then that it caused liver cancer to workers. And I'm sure that occupational safety practices are vastly different now than they were in the 1970s. But the truth is that the original 1976 law that was supposed to ensure the safety of existing chemicals never really lived up to that promise. And what the Nixon administration said to Congress at the time, it's a great quote, so I hope you don't mind if I read it.
Please.
This is what they said. "We should no longer be limited to repairing the damage after it has been done, nor should we continue to allow the entire population or the entire environment to be used as a laboratory." That was what the Nixon administration said when they asked Congress to rate the original law. The original law failed to protect people against existing chemicals, but the 2016 law that you and so many members of this committee worked on has that potential. And I think we'll be able to see it realized, not just with TCE and vinyl chloride, but with many of the other chemicals that are long overdue for a look.
So it's not a ban on the transportation of it. It's whether or not it should be manufactured at all, because it's too dangerous when human beings.
Or whether
are
it
exposed.
should be manufactured and used in a way different than it currently is.
Yeah. Thank you, Mr. Chairman.
You bet. Thank you, Senator Markey. Senator Kramer, welcome.
Thank you, Mr. Chairman, and thank you, Assistant Administrator, for being here. And thank you for the response letter to me and several of my colleagues in both the House and the Senate regarding chlorpyrifos and the Eighth Circuit's vacating of the final rulemaking. But for the benefit of the dozens of people watching this online somewhere, and the farmers and of the prairies and throughout the country, I want to ask you to drill down a little bit on some of the specifics in response. Specifically, is the EPA beginning the process of restoring, or how are you restoring those tolerances? Maybe, and I'll give you all of them up front, and then you can just elaborate. To include like timelines, if you have some specific timelines, what's been done. I would also just add, on behalf of several constituents, they feel like the EPA's been fairly, well, not very specific. That's been, some of the statements since the vacating of the rulemaking have not provided very much clarity. So what I want to give you the opportunity to do over the next 4 minutes is provide that clarity for them, drill down a little bit on the specifics, the timelines, the tolerances that'll be restored and whatnot, if you could, please.
Happy to do that, Senator. I actually met with a bunch of the grower groups yesterday on this question, and they told us about some of the confusion that some of the state regulators have, and we're following up on that because we did try to reach out to everyone in advance of our December statement, but we clearly need to do a better job and need to talk to more people. So first of all, what the Eighth Circuit did was it vacated EPA's rule that took away the permission to use chlorpyrifos on food crops. So that decision has already happened, and all of those permissions to use chlorpyrifos in food are back in effect. EPA has to write basically a technical correction to the Code of Federal Regulations. I think that's happening next week, but it's already in effect. I think the next thing that we're doing, and the timeline on this I can't be quite as specific about, is the Eighth Circuit decision, as well as a 2020 document that the agency put out on chlorpyrifos, really focused on 11 uses of chlorpyrifos that had high benefits. Yes. And so what we're working to do is talk to the companies that make the pesticide in order to incorporate some additional mitigations that were talked about in the 2020 decision, as well as some of the Endangered Species Act work that we need to do in order to comply with that law. I know those conversations are well underway, but since it's a conversation with external parties, that can't be more specific about when we'll be finished.
Well, and the whole thing's about 2 months old. So it's just, you touched on the confusion that seemed to sort of permeate the early statements. All I would say in wrapping up, Mr. Chairman and Madam Assistant Administrator, just be as clear as you can be, because this is very, well, we're heading into, as hard as it is to believe in North Dakota today, we are heading towards spring and the new seasons and all of that. And so it's everybody from the manufacturers, the suppliers, the users themselves, the producers themselves that seek this clarity. It's critical to get it done in a timely fashion. I appreciate your attention.
Absolutely. And if you get questions and people are still confused, just send them to us. Our staff want to be clear also. So it actually helps us when people come straight to us and ask us the questions.
Appreciate that. Thank you very much. Thank you, Mr. Chairman.
You bet. Senator Markley, if you're ready, you're next in line, and then Senator Ricketts.
All right, thank you, Mr. Chairman, and welcome. Good to have you. OMB is currently reviewing asbestos Part 1 rule for chrysotile asbestos. Can you give us a sense of a date when the final rule will be available?
Well, thanks very much for that, Senator. As you know, it's our first Section 6 rule that went through the new process, and it's not an accident that it was the first one. Because of the symbolic significance of the failed asbestos ban from the 1980s, and the fact that asbestos continues to kill tens of thousands of people every year. So it's at OMB. I think the 90-day deadline, or the 90-day period, ends maybe I think it ends in early March. It's hard to predict, though, since it's not in our control, whether we'll hit the early March timeline or not. But I know we're in very active conversations with our agency partners and are really eager to unveil that final rule.
Well, it takes continuous advocacy because things go to OMB and just disappear. It's like a forever, like what the hell happened to it? So I hope you'll keep pressing and keep us posted on that. So this rule only affects one form of asbestos, but there's 7 other asbestos types of fibers. Does EPA have a plan to address the additional asbestiform varieties?
Yes. We are in the middle of asbestos Part 2. As you might remember, when the last administration chose to only study cracetyl because that form is the only form used in ongoing uses, there was an adverse court decision that caused the agency to have to split that risk evaluation and rule into two. So we're working on the second part of asbestos, which includes the other forms, it includes legacy uses, and it includes, reasonably available information on its presence in talc. And we expect to both release a draft and final risk evaluation for Part 2 in this calendar year.
Okay, thank you. I'm glad to hear that. So one concern that we've heard about is in the peer review process. And EPA released the peer review comments, and one reviewer wrote that, quote, "The members of this panel who are reviewing this document have been told we are not to talk to one another. We have been told there will be no conference calls with one another. We have been told there will be no face-to-face meetings. This is entirely inconsistent with the 40-year history of EPA science advisory panels," end of quote. So I have concerns about that point. And I have heard EPA saying, well, we're not going to let people talk to each other because we don't have enough funding. And we're not going to have conference calls if we don't have enough funding. But a lot comes from people actually sharing their comments with each other. Is this an accurate description of what's going on, and why is this a good process?
Well, thanks very much for that question. And first of all, let me just say that we think the scientific advice that we get from our peer review committee is invaluable, and and we really do listen to what they say and take their input seriously. Where I think it's also a pretty standard process, though, to do letter peer reviews of scientific documents. And one of the reasons why we moved to doing that for asbestos Part 2 is because a lot of the science, the exposure models and other information that we're using for Part 2, we had already had peer reviewed when we went through the Part 1 risk evaluation. And we also felt that moving to a letter peer review in this case would also really help us finish that Part 2 risk evaluation more quickly. So I think I don't want you to come away thinking that we're abandoning the peer review process. We're absolutely not. I think we did choose for the first time to try a different approach for this one, and part of the reason for that was our sense of urgency in completing that risk evaluation.
Mr. Chairman, I think this is something we need to take a further look at. The idea scientists are being told they can't talk to each other, and not told even Zoom meetings in person. I don't think you get the best result having individual people told they're in silos and have to operate without kind of the process of consultation. So I'm not sold.
Okay.
And count me skeptical.
I appreciate it.
Okay.
Thanks.
And my final question, actually I'm out of time.
Yeah, just make it a brief one if you would.
Okay. So in terms of PFAS, it's not a short question, so I may have to submit it to the record or just follow up with you, but really
If we could do that, that'd be.
Okay, that's what I'll do. All right. Thank you.
Thanks.
Yeah, thanks very much. Senator Ricketts, good morning.
Good morning. Thank you, Chairman Carper and Ranking Member Capito, for holding this hearing today, and Dr. Friedman, thank you for joining us. I have a few examples behind me of chemicals that have undergone the TSCA process, which are critical for global food production. Formaldehyde is necessary for livestock production to prevent disease. And while you all may know that Nebraska is the beef state, something you may not know is that we are also the global leader in irrigation system production, such as what you see here is a center pivot. Actually, about 80% of all the world's center pivots are made in Nebraska. And vinyl chloride is critical for the irrigation tubing, hoses, and drip lines. Both ethylene oxide and acetaldehyde are used in the production of crop protection tools, protecting our food supply from insects and disease. And these examples really exemplify the importance of predictable and reliable permittance of chemicals. As governor of Nebraska, I implemented Lean Six Sigma for our state agencies to improve our processes. And my understanding is the Trump administration established an Office of Continuous Improvement at the EPA to implement the Lean program with the EPA, and we talked about this a little bit yesterday, Dr. Freeman. And this is, again, just really, I was just looking for a simple yes or no on these. Does the new chemicals program still utilize the Lean program?
No, but we do seek to continuously improve through many of the same approaches that are in Lean Six Sigma.
And does the Office of Continuous Improvement still exist at the EPA?
That I'm not sure about, but I know there are agency-wide conversations about ways to improve our processes, and when one part of EPA comes up with something, it's actually shared throughout the agency.
Well, there are clearly other process improvement methodology besides Lean Six Sigma, but if you could follow up with me on the Office of Continuous
Sure.
Improvements, if that still exists at the EPA. Also, we've heard that one of the problems holding up PMNs are changes to the staff contacts throughout the process. If a new project manager is assigned to a PMN, will you commit that to us that project manager will then notify the submitter within a week to let them know that there's been a change?
You know, I think that's an incredibly reasonable idea, and we'd be happy to do that. I think that would improve transparency for everybody.
Great. Thank you very much, Dr. Freeman. The EPA issues existing chemical exposure limits, in other words, regulating chemicals throughout the workplace exposures. However, there are multiple times more stringent than the rest of the world. These limits are based on information from EPA's Integrated Risk Information System, or IRIS program, which is not congressionally authorized and is a hazards-based program. This is not consistent with the agency's statutory mandate to complete risk-based chemical reviews using the best available science. Not to mention that OSHA already is completing the work on this through some of their enforceable permission exposure limits. In addition, the American Conference of Governmental Industrial Hygienists established exposure limits far above EPA's ECHLs. These values are regularly updated following industry standardization practices. For many of the chemicals under EPA review, including asbestos, methylene, chloride, this one, I'm in a biology major, perchloroethylene, carbon tetrachloride, and trichloroethylene. The ECHLs.
Would you say that again?
I thought I did about as good as I could the first time through. The ECHLs have come out after the proposed and final risk evaluation. Some with proposed risk management rules, which left stakeholders with no real opportunity to comment on these levels. This is a significant problem, is compounded by the fact that these numbers are extremely low, often below the level of detection, and much lower than regulatory numbers in the rest of the world, as we kind of mentioned. Setting levels below the level of detection is de facto a ban on these chemicals. For clarification, when you set a final regulatory ECHL for industrial uses, does that mean there is a level at which no unreasonable risk exists?
I think what we're saying for some of those levels is that the proposed exposure levels that came out address the unreasonable risk that was identified in the risk evaluation. But it's important to understand that the risk evaluations are prohibited by law from considering costs and other non-risk factors, like the point you made about them being unimplementable. So I think as we move through the regulatory process following the risk evaluations, we're engaging pretty actively with industry to make sure that we really understand what their occupational safety practices are, can achieve. And I think you'll see some shifts in our approaches between proposed and final rules for some of the chemicals.
Okay, thanks. So if I understand what you're saying, and correct me if I'm wrong, that the process that's been set up and the rules have been established and the laws have been passed actually make it so that you recommend some of the risk levels below detection level because you're not allowed to consider other factors. Is that accurate?
Not quite. In the risk evaluations, we're not supposed to be considering costs or other non-risk factors. When we write rules, We 100% consider those things. So I think in an exchange I had earlier with Senator Bozeman, I believe it was, if we get, going forward, if we get a draft risk evaluation that leads to a math outcome that the draft proposed occupational safety limit is below background levels for that chemical, we'll say very clearly in the draft risk evaluation that that number won't be the basis of our rule.
Okay, so it's not a de facto ban in that case, then?
No.
Okay, great. Thank you very much, Dr. Freeman. I appreciate you explaining that to me. Thanks.
Senator Ricketts, thank you for those questions. I think Senator Fetterman's trying to get here to join us. Do we expect any other Republican colleagues to join us?
Senator Lummis may be on.
Senator Lummis, okay, good. All right, good. I want to return to the issue of new chemical review for a minute or two. As you know, our committee has consistently heard concerns from a broad spectrum of stakeholders about the pace of new chemical reviews. Specifically, the chemical industry believes that EPA is moving too slowly, and whereas others are concerned that EPA is not being thorough enough. Dr. Friedoff, your office has taken some innovative approaches to improve the pace of new chemical reviews. We talked about some of that already. My question is, would you please elaborate on some of those approaches, and specifically what has worked well, and how have those approaches allowed EPA to review these new chemicals faster while also being more thorough? And where might there still be room for improvement? In the spirit of everything we do, we know we can do better. Go ahead.
Well, thanks for that question, Senator Carper. And I think we've talked about new chemicals a little bit in this hearing, and I really do think that there is still upside in what the agency can deliver. And I think we've already demonstrated some, but I think we can continue to do more. So it used to be that when EPA didn't know enough about a new chemical before the 2016 amendments were passed, that chemical went right into commerce without a formal EPA review. And so as a result, there's a whole bunch of types of chemistries that EPA never really had to write anything down about. And one of the things that we've tried to do is work to write down the science policy that would allow us to standardize and streamline the review for chemicals that we see a lot. So one example, mixed metal oxides, which are used by the battery sector in particular. We had companies tell us that they expected to send us dozens of those every year as we move to increased electric vehicle production in this country. And so we decided we really needed to get ahead of that and worked on our science policy and risk assessment approach for that class of chemistry. And we're doing that with other sectors too. The fragrance sector has a couple dozen PMNs that have been stuck at the agency because of science questions like that. And while I don't think we can do the exact same thing for the fragrance sector as we did for the battery sector, we are convening a scientific workshop with them and other stakeholders next week, I believe, to try to work to figure out what the answers to those questions are so that we can move those PMNs along also. So it really is a classic work smarter, not harder, modernize our approaches, be strategic about where we focus our resources, and try to increasingly improve both our speed and our protectiveness.
Let me ask one more question, and then we'll turn to Senator Lummis. There are differences of opinion, as you know, about the amount of money that you need to run the programs in your agency. The House has proposed further cuts to the TSCA program in its FY24 appropriations bill. Can you give us a sense of how you will prioritize your work if this is enacted, and what will have to be sacrificed?
Well, thanks for that question, and it's important to remember before the law was changed, EPA did 0 comprehensive risk evaluations. And of the 30 chemicals that have gone through the process, we've met the statutory deadline for only one of them. Before the law was changed, we wrote 0 comprehensive rules to protect people against some of the most dangerous chemicals that have ever been made or used in this country. Now we're in the middle of working on 10 of those, and we've missed the statutory deadlines for those as well. We've talked about our consistent struggle since the new law was enacted to meet Congress's expectation that new chemicals would be reviewed protectively within 90 days. The House budget would take us back to the budget of the old law that didn't do any of the things that the new law has told the agency to do. So what it means is that the workers and communities who've been waiting for decades to get the protections they need will have to wait longer. And what it also means is that the new chemistries that are needed to reshore the domestic manufacturing of everything from semiconductors to biotechnology to refrigerants to comply with the AIM Act to, all of these other chemistries, they'll need to wait a little bit longer too, because we simply won't have the resources to do what Congress expected us to do.
All right. I think that's an important point for us to keep in mind as we go through the appropriations process in the days to come. Senator Lummis, we're delighted to see you. Welcome aboard.
I'm delighted to see you too, Mr. Chairman. Thank you very much for holding this hearing, and thank you, Ranking Member Capito. My questions, at least, are going to start with PFAS. As you know, there's ongoing debate over the definition of PFAS as it applies to a range of federal regulatory regimes. I'm concerned that there is no current, consistent, agreed-upon definition for these chemistries being used across government agencies. While some PFAS chemistries may need urgent regulation to keep our communities safe, I'm concerned that EPA is needlessly restricting critical PFAS chemistries essential for American manufacturing. And I'm not the only one that's concerned. Mr. Chairman, I'd like to ask unanimous consent to enter into the record a report from the Department of Defense on critical applications of PFAS substances.
Without objection.
Thank you. Now, I want to quote from the Department of Defense report. It says, losing access to PFAS due to overly broad regulations or severe market contractions would greatly impact national security and DoD's ability to fulfill its mission and impact domestic industrial manufacturing and supply. The report raises concern about regulatory risk to our nation's national security, industrial base, and overall economy on page 15. After all, as the report reminds us, the DoD is reliant on commercial industry for its applications. So the report cautions there's no consensus on PFAS definitions, and a simple grouping together of over 38,000 specific individual chemicals does not inform whether a compound is harmful or not. So, first question, are you aware of the 2023 DoD report regarding PFAS?
Yes, Senator, I am aware of it.
Okay, does the EPA intend to establish an expedited review process for PFAS with less concerning hazardous profiles, or for those used in limited volumes but critical to technological innovation?
Yes, actually, my office has already developed a framework just like that. And what it basically says is if the PFAS is going to be used in a sophisticated industrial environment, like, say, the semiconductor sector has, workers are protected, environmental releases are controlled, there will be a path through the new chemicals program for PFAS like that. And we agree that while PFAS have unquestionably contaminated a large number of places in the United States, we also think that if the new chemicals provisions of the 2016 law had been in place all along and EPA had been charged with making sure that the new chemicals were being used responsibly, we would have a lot less PFAS pollution in the country than we do now.
Have you met with DoD to try to go through with them which of those PFAS chemistries they believe are pivotal to national security, as they mention in the report, and those that are not?
I've met with DOD myself a number of times, not just on PFAS, but on other chemicals that are going through the TSCA process. And we are very committed to continuing to work with them to make sure that our work in the chemicals office doesn't undermine military readiness or remove their access to things they need to do to keep us safe.
Okay, can you help us by returning to this committee a list of these 38,000 chemicals that DOD feels that they need to have access to without undue restriction, and those that you feel are appropriate for higher scrutiny?
I'm not sure how I'd go about that list without knowing exactly what DOD needs, but I can also say that there's more than two options under TSCA. It's not use it without restriction or ban it. There's also use it responsibly. And I think that's what we're striving for when it comes to critical uses of chemistries, not just PFAS, but some of the others that we're looking at as well.
Okay, what might that look like?
It could just be don't dispose of it in sources of drinking water. It could be make sure that when your workers are handling it, they're protected either with PPE or with engineering controls that prevent exposures to them during key tasks. It's a whole range of things, and I don't think the choice is ban them all or continue as we have for the past, decades in ways that clearly harmed human health and the environment.
Okay, as you know, we're sometimes demanding that we onshore products that we've offshored, and then we want to restrict them from onshore manufacturing to the point that we can't onshore them. And so we are sort of giving with one hand and taking with the other. And I think that this is an area, chemistry, where there needs to be some very careful consideration, working with industry, working with Department of Defense to make sure that we're finding the sweet spot. I thank you for your testimony, and Mr. Chairman, I yield back.
You bet. Thank you for those questions. Next, we're going to recognize Senator Merkley again, and if we're not joined by anyone else, Senator Capito would be after Senator Merkley. Senator Merkley.
Thank you very much, Mr. Chairman. As long as we're on PFAS, EPA finalized a rule in September of last year that requires reporting from manufacturers to share data about the chemical identity, the uses, the volumes made in process, so on and so forth. Doctor, when will that data collected by EPA be available to the public?
I know that it's due for different reporters at different times, but I think we're expecting to get it next fall, or start getting it next fall, and I know we'll be working to make as much of it public as we can.
So does that mean it's not clear that the public will have access to that data?
I mean, the law requires us to protect confidential business information, so if we get something into the agency that is marked that way, we'll have to take some time to review it and make sure that we can get it into a form that the public can see. But the entire point of that data collection effort, which was something this committee actually wrote the law directing us to do, was to make sure that that data was available and useful to everyone who might want to see it, including members of the public.
Yeah, I hope that that information, which will help inform the PFAS debate extensively, is available to help inform the debate. Thank you, and the understanding of the challenge. I want to turn to plastics to fuel. Pyrolysis is being advocated by many to be able to essentially use heat to return plastics down to a state where it's essentially once again fuel. And then the EPA has studied, well, what happens if you have that in a marine setting? What happens if you have that in an airport jet setting? And EPA's model produced a lot of concern, a lot of articles written about the high level of toxicity, really way exceeding the standards that we normally have, producing cancer in 1 in 10,000 as opposed to the standard of 1 in 1 million. a 1 in 4 cancer risk from a lifetime exposure. And then I think EPA said, ooh, well, that's scary. Let's just set this whole model aside and then approve the chemicals. How does setting the whole model aside and then just approving the chemicals serve the scientific process and the whole goal of TSCA to evaluate chemicals with deliberate scientific analysis?
So there's a lot in that question, Senator. So first of all, the original chemicals that took the plastics and turned them into fuels were approved in 2015 and 2019. And what we looked at was taking what companies wanted to do, which was to take small amounts of those chemicals, mix them with traditionally drilled fuels, put them in a refinery, and come out with something that looked, for all intents and purposes, exactly like normal jet fuel or normal marine fuel. So I think our staff was quite convinced that the safety profile of the resultant fuels was going to look exactly the same as what you would get if you just drilled for oil and put the oil through a refinery. That said, I do think that when our exposure model spit out numbers like that, we should have done a better job at reality checking ourselves. When we did that after the fact, we learned that, it was sort of clear that those exposure models are exceedingly conservative. They basically assume that 100% of the fuel burns in one location and the same person stands there and breathes 100% of the exhaust fumes from the plane in at one time. And so that's clearly not a real-world scenario, not a real-world risk, but it was on us to explain it better, and we are learning a lot from that experience.
Or to go back and say, we think our assessment model was flawed, and now we're going to get a more realistic assessment model, and then actually use an assessment model rather than just throwing it to the side and ignoring it.
So I think that what we learned, normally when we don't have actual exposure information, which is often the case for a new chemical, we just assume that the worst case scenario is some set percentage of it gets into the environment, or some set percentage of it, exposes workers. But that model fundamentally fails when the end product is a fuel that is supposed to be burned.
Yeah.
And that's why, but I agree with you, we should not be doing it that way for transportation fuels.
Well, and I
going
do think
forward.
the reason it's raising concerns is that the plastics themselves have huge numbers of contaminant chemicals. So the pyrolysis process vents off a lot of stuff, and often, and we've made an emphasis on environmental justice in this community, in communities that are poor, in communities that are primarily black and brown communities. And then those same contaminants survive and are in the fuel when it's burned, and therefore our evolving understanding of this potential pathway, which could involve fuels that are not just a slight amount added to some other fuel, but burned in the whole, as folks try to get kind of more circular economy. There's significant concerns that should not be ignored in this process.
I agree with you. I think we know a lot more about those potential impurities now than we did in 2015 and 2019 when those original chemicals were approved. And I think our policy going forward, including for these particular fuels, is to make sure that there aren't impurities like that if companies are going to move forward with a process that creates those fuels.
Thank you.
All right, thanks, Senator Merkley. Senator Capito.
Thank you, Mr. Chairman. Thank you. I'm going to kind of go back on a few things that have been alluded to in some of the questions. It seems that there's been a question of EPA's interpretation of what is reasonably foreseen. So is it reasonable to foresee that somebody would drink bleach? Of course not. None of us are going to drink bleach. But these, well, I wouldn't say none of us, but these speculative, unintended uses of chemicals are being used to justify overly stringent restrictions. Do you believe that every potential use of a chemical, including the intentional misuses, are reasonably foreseeable or a reason to restrict?
No, I don't.
Well, good, because I believe what we're hearing too is that sometimes your office will continue to assume noncompliance on OSHA standards, and Senator Ricketts kind of alluded to the OSHA issue. I, in my opening statement, talked about emission creep here. what is your relationship in terms, I mean, how do you put the bright line between where you are and what OSHA is? And it sounds like you got more than enough on your plate. Not sure you want to go into what OSHA's doing as well.
So TSCA says that we have to consider the risks to potentially exposed and susceptible subpopulations, and that term is explicitly defined to include workers.
To what?
It includes workers. It explicitly by
Okay.
law includes workers. So OSHA wrote most of its chemical-specific rules in the 1970s. And when you go on their website, the very first sentence that you read is that their standards are outdated and inadequate for the protection of worker health. That's what OSHA says about its own chemical safety worker rules. The other thing is that OSHA rules don't cover everybody. They don't cover self-employed workers, and they don't cover public sector workers that aren't subject to a state OSHA plan. So even if the OSHA rules weren't outdated and inadequate for the protection of worker health, we would still need to recognize that some of the workers that the TSCA risk evaluation uses cover wouldn't be subject to them in the first place. So what I do think we're trying to do is work extremely closely with both OSHA and NIOSH. We're trying to align what we write in our final rules to be as consistent as possible with what their practices and approaches are for things like monitoring and detection. And I also think we're working really closely with industry because in many cases, industry has gone way beyond those 1970 standards when it comes to protecting their workers because those standards are outdated and the sophisticated companies know it. So we're also trying to align with the best industry practices that we're made aware of as well, and make sure that our final rules are implementable.
Well, I mean, I guess my interpretation of that would be there's laxness or inadequacy in a particular different part of the Department of Labor is obviously where OSHA is. I just think with what we've kind of uncovered and agree where some of the issues are, staying in the lane would probably be helpful. Let me ask you another thing to clarify, because I said this in my opening statement, and I want to make sure we're in agreement here, where I said that companies are opting to go offshore to create chemicals and that your applications for new chemicals are down, therefore your user fees, we're getting to the resource thing. The user fees are going down, the amount of people paying user fees is going down. Is that an accurate statement from your viewpoint?
I don't think so. I think it was accurate for a couple years after the enactment of the 2016 law, but we've actually seen new chemical submittals, kind of come back up to what they've been historically in the last couple of years.
Well, we need to follow that because that's, I think, an important issue in terms of being able to move forward. Another question is, there is an ability, because you're talking about being resource constrained, there is an ability for you under the Intergovernmental Personnel Act to be able to access other federal employees at no cost to your agency for specialized things. Now, we see this in endangered species, in fish and wildlife. We see them borrow from other agencies when they have a large request. I've seen that in my own home state. Is this something that you've considered and to fill in the gaps that you say that you have?
Yeah, actually, we've already done that. In the, remember the FY22 budget, which gave us a really small increase in resources, wasn't enacted until March of 22. So that was sort of more than a year of this administration, with a flat budget. And we actually did borrow some staff from other parts of the agency specifically for new chemicals because of the dire situation that new chemicals was in. I think it's one of those things, though, that most federal agencies, including EPA, have resource issues and have workload issues, and other parts of the agency also have laws that they have to implement, and so there isn't an infinite capacity for us to be able to do that, but we have done it on a temporary basis with new chemicals.
Okay, so I think we have a lot of agreement, and we'll keep working on that list that we put forward. I don't want the hearing to end to have any kind of misunderstanding that questions or accountability issues means that any of us, certainly me in particular, would want to sacrifice any kind of safety issues around a chemical use for speed. But we do have certain deadlines in the law. You were probably around when TSCA was written, and those were established to be reasonable deadlines at the time. And so there's a reasonable expectation that those can be met. And so I think, while I expressed to you last week the frustration I have as a member, and I think probably all of us, doesn't matter what side of the aisle you are, it may matter what administration it is, it's always, I just need more money. If I had more money, I would solve every single problem. And, you know, it's sometimes we have to be more efficient, we have to be more innovative, we have to be more, use the authorities like Title 42 that we have to be able to move forward for more specialized investigations, listen more to the stakeholders, all these kinds of things I think we could make improvement on, understanding that the resource issues, but you have gotten more resource issues, and certainly EPA, 2,000 more people. I mean, can the administrator reprioritize? I mean, this is an important area, because another thing, then I'll get off my high horse here, is if we look at chemicals, I think the assumption is sometimes, well, you just want more chemicals and they're going to be more hazardous and more flammable and more, everybody thinks it's always the bad part of chemistry. The good part of chemistry is getting held up too. The chemistries that would take our old chemistries off the shelf and make improvements, have better health outcomes, maybe even be more efficient, maybe even be more economical to use, and certainly can be made here. They're getting held up at the same time. And so we'll just continue to monitor this. I appreciate your frankness, and thank you for coming.
Thank you.
Senator Markey, if you're ready to go again for another round, I'll recognize you. Otherwise, we'll recognize Senator Whitehouse. I think we all would. Senator Whitehouse.
Thank you, Senator Markey. Thank you very much for being back here again on one of our favorite topics, and one where I think we did some very good bipartisan work. I think of Senator Inhofe, who was not always somebody that I agreed with, and our good work together on this issue. I would like to ask you about the process involved. As you recall, as you know, we set up a process where the industry would make application to go through the TSCA process. And what I hear we have seen is a lot of industry revisions of the application. And could you tell me, first of all, is that true? How often is that happening? How many? Are there multiple revisions sometimes, not just one, but a cascade of cumulative revisions? And what effect has those revisions had on the ability of EPA to meet the schedule and proceed to the conclusion of the process?
Yeah, thanks very much for that question, Senator. And you're right. Sometimes companies do come in towards the end and give us new information that we wish they'd have given us at the very beginning. And that causes us to have to redo parts of their risk assessment. And that doesn't just delay their chemical, it delays everybody else who's waiting behind them in line. I think some of that is a reflection of the still pretty young law. You know, companies don't necessarily know what we need to review their chemicals quickly. So one of the things that we've really tried to do is outreach to industry, do webinars, do trainings, really kind of tell them from the beginning, this is what we really need to review your chemical as quickly as possible. So some of those efforts are working, but I think we could do more, and I think industry could do more to get a complete application in front of the agency in the first place, and I think it would have benefit to everybody.
Is the source of these revisions just confusion, or do you think there's also some motivation to delay?
I don't think there's a motivation to delay on the new chemical side. I think what happens is they didn't write down in their application that they were going to dispose of the chemicals properly. And then when we do our risk assessment, we assume they're going to release it to water. And then they see that and they say, oh, we weren't going to do that. And we say, well, you should have told us that from the start. It's a lot of those kinds of changes. I don't think they're intentional. I think they're a little bit, lack of experience, a little bit of of a failure to
Straightening
to
out the
realize
kinks.
that the more they give us, the better it is for them.
Okay. And you think the kinks in the process have now been, I think, worked through pretty well?
I think it's a work in progress. I think we've made a lot of improvements, but it's important to note that before the 2016 law, we only did formal safety reviews on about 20% of new chemicals. Now we have to do them on 100%, and for the first 6 years of the law, we got $0 extra dollars. So we were, so the agency was sort of hamstrung for a good long time. And now that we've gotten a modest increase in our budget, we are working to build in some of those efficiencies without losing the protectiveness of what we're supposed to be doing.
How many employees does EPA have? 13,000?
Ish, yeah.
Ish, yeah.
Yeah. So we've, in the new
Little
chemicals
context number.
division, in the new chemicals division, we were able to hire 14 new people with the FY23 budget increase, with a handful more that are still in the works. So we're not at 15,000 people in the new chemicals division.
No, I get that. I get that. When I worked in the Department of Justice and there was an urgent matter, they would detail people from the field into headquarters to work on it, just as they've done with the January 6th prosecutions. So I think I hope that EPA is at least considering borrowing from the regional offices and putting people on detail for significant projects like this where the immediate staff aren't sufficient to meet the new need.
We've done some detailing, and we'll continue to do that. I do think some of the expertise we need is pretty specialized. There just aren't that many toxicologists around who know how to study exposures. So another thing that we've done is we've dedicated a person in the toxics office to really revamp our recruitment process and really go places to advertise the jobs that we have that we hadn't previously gone. So now we're getting a lot of qualified applicants for those jobs, which is great, but it hasn't always been the case.
Well, thank you. It's great to see progress in this area. Thank you very much, Chairman.
Thank you, Senator Whitehouse. Senator Fetterman, welcome. You are recognized. Thanks. Good to see you.
Well, first, I just have to acknowledge your recent happy birthday to the chairman.
Thanks so much. I ate more chocolate
What,
cake yesterday.
63, was it?
God bless you.
Anyway, and thank you. And then, I live across the street from a steel mill, actually the largest steel mill in my state, one of the remaining ones left. And I have some personal experience for myself and my family of the impact of the industrial sector and how that can have on the surrounding community. And I don't believe that we don't have to choose between keeping good union jobs and also verse against a clean, safe environment. Do you agree how you are seeing the dynamic playing out, how you lead the EPA's work regulating toxic substances?
Yes, Senator, I do. As we talked about last week, I really don't believe that you have to choose between good-paying jobs and having clean air to breathe and clean water to drink. And one thing that we've been doing is working really hard with the sectors that are trying to bring good jobs into this country to make sure that we're approving their chemicals more quickly or as quickly as we can. So for example, we've prioritized the chemicals that are needed by the semiconductor sector, by the battery sector, by the biotechnology sector, and put those to the front of the line whenever we can. And now we approve those in about a third of the time as compared to other sectors. So we do think that you can use chemicals responsibly, keep your workers safe, keep communities safe, and do well as a company.
So, and the EPA, of course, is at the, so if you're familiar with the history, who established the EPA?
President Nixon.
Nixon? Well, he was a Republican, right?
He was.
That's right, he was. Oh my gosh. So actually, the fact that the EPA was founded by a Republican, and now it's really a shame that sometimes that's drifted away from us. Where now, and that gets weaponized here. Where we have to, two things can be true at the same time. That we need to maintain and protect good union jobs that sustain a community and families, but also we a clean environment's pretty useful. I mean, I think it's useful all the time. And I think both can happen together. And I'd like to remind everybody that a lot of the important environment things were done under leadership of a Republican administration. And now moving on, of course, we're all familiar with the Norfolk Southern train derailing, of course, in Ohio, and that's very close to my state's border. And it released more than 100,000 gallons of vinyl chloride into our community. I'm sure you know. And last month, the EPA announced that the vinyl chloride would be prioritized for considering under the Toxic Substance Control Act. But we are still looking at years of that evaluation to be finished and the safety protocol to be recommended. Why does this process take so long?
Well, thanks very much for that question, Senator. And ironically, it was the Nixon administration also that asked Congress to write the Toxic Substances Control Act, and they actually used vinyl chloride as one of 3 examples for why that law was needed back in 1971. And they basically said, when they asked Congress, this is what they said. They said, we should no longer be limited to repairing the damage after it has been done, nor should we continue to allow the entire population or the entire environment to be used as a laboratory. And that was the Nixon administration's reason for why Congress had to write TSCA in the first place. When Congress rewrote that 1976 law, it was because it wasn't effective. It was because when EPA tried to ban asbestos, a chemical that has killed tens of thousands of people every year for decades, EPA's ban was overturned in court, and it rendered the original law unable to be used. And when Congress came together and wrote the 2016 law, it defined fairly prescriptively the process by which EPA was supposed to review those thousands of chemicals, including vinyl chloride, that hadn't been evaluated before. And the timelines in the law are very clear. We need to spend a year with 2 public comment periods before we can start work on vinyl chloride. Once we do start work on vinyl chloride, the law says we've got 3 to 3.5 years to finish our work and really comprehensively assess all the risks. After that, it's a year to propose a rule and a year after that to finalize the rule. So it is a long process. But the idea was, instead of doing little, we'll regulate this use here and that use there. The idea behind the law was we really want to comprehensively study all the ways in which a chemical is made and used and write a comprehensive rule using that best available science in order to give the public confidence that the chemical can continue to be used safely for the uses that we think can continue.
Okay. Mr. Chairman. Thank you, and thank you.
Yes, Senator Brunner, thank you for those questions. And Senator Lummis, you're recognized again, and the vote is underway. I think we're about 10 minutes into our first vote of a couple of votes. Senator Lummis and then Senator Markey.
Yeah, thank you, Mr. Chairman. And I do appreciate the perspective of the gentleman from Pennsylvania. I, too, live next to a refinery and have benefited personally from the existence of the RCRA law. Without which we would have had no remediation of significant migration of hydrocarbons into the creek where our cattle drink. So this is a bipartisan subject. This is not partisan. Reasonableness becomes the issue. So I want to return to the ECHL's draft rules. I've heard from experts in industry who say there's no realistic way to implement some of the draft rules on ECHLs. So my question here is, when you hear from industry that there's no realistic way to implement a draft rule, will any of the proposed changes be adopted between the proposal and the final rule?
I do think we're working quite closely with industry to understand what might be needed by way of adjustments to make those more implementable. I will say that for a number of our chemicals, the data we have shows industries already either meeting our proposed levels or pretty close to it. But They will change between proposed and final sometimes. Sometimes it might be more time to come into compliance. Sometimes the numbers themselves might change. I don't think I think when we propose a rule and look for public comment on it, we're serious about reviewing those comments and making adjustments whenever we think they're needed.
Question about existing chemicals that were never peer-reviewed. It's my understanding that EPA's worker exposure levels for existing chemicals were not peer-reviewed. Can you commit to ensure there will be peer review and public comment on these values going forward?
Yeah, just to elaborate a little bit, the last administration wrote the risk evaluations, and I think they were in such a rush to get them done that they didn't really think a few steps ahead for how they were going to do the worker protection, how they were going to address the worker protection risks that they found. So that's why those exposure limits came out after the risk evaluations came out. I will say all of the data that went into deriving those limits was peer-reviewed.
Okay.
That said, I also know that industry really wants to see them earlier in the process, really wants to see them go through the peer review process, and I think that's entirely reasonable, and that's what we've started to do and will continue to do going forward.
Thank you. Question about hazard-based review of a new chemical. Can you explain to me what factors are considered in a hazardous-based review of a new chemical and how that differs from the standard applied to older chemicals under TSCA?
Sure. Well, I think with existing chemicals, we have a lot of data. Sometimes we have data like in Woburn, Massachusetts, where we know that exposure to TCE caused a cancer cluster. And we have information about what that chemical did to people that were exposed to it. With new chemicals, we don't have that usually. So what we have sometimes are tests that the company has put together, sometimes using non-animal testing to show what the new chemical's expected hazard might look like. Sometimes what we do is we look at the structure of the new chemical and compare it to something that we do know something about, and infer what we can from reading across what we know about an old chemical to what we can expect to happen from the new. So it's a variety of techniques, but with new chemicals, they're by definition new. There's less information about them.
Yeah, I appreciate that. Mr. Chairman, I want to just return for 1 second to the PFAS discussion and just remind you that DOD's report kind of sets off some alarm bells about the importance of working closely with DOD. And so the debate over the definition of PFAS is going to be extremely important to them. And just to implore you to work closely with Department of Defense on these definitions and to try to make sure that we're not compromising our national security or our defense posture by a regulatory regime that's so rigid that it provides no escape valve. Thank you. Thanks for being here. I yield back.
Thanks for your focus on PFAS and permanent chemicals. It's much needed and much appreciated. We've been advised by the cloakroom that we're almost 20 minutes into our first vote. So, Senator Mark, I'm going to recognize you, but not for a real long time. But thank you.
No, I appreciate it. But I was willing to wait a good long time in my Chevron deference to Senator Whitehouse to go first, not understanding
Right.
all of the implications of that decision in terms of other people who would be asking questions. So I thank you for that. The Trump administration violated TSCA by ignoring fence line communities in its chemical exposure and risk analysis. So, and what's a fence line community? Well, I guess I grew up in a fence line community because I lived 3 blocks from the Malden River, and my mother told me when I was 10, whatever you do, Eddie, don't swim in the Malden River, because it was black with a kind of a pre-Jimi Hendrix purple haze over it because of the coal companies, the chemical companies, all of the polluting companies right along the Malden River, right? Just don't swim in that river. You know, of course, there were no fences in that era, but now the companies put up a fence, but 100 feet later are the homes the kids who are playing, and then it goes out for another couple, 2, 3 miles. And what happened was there was an underestimation of the harms, and it undervalued the lives of environmental justice communities living near polluting facilities. And the Biden administration made the right call by changing that harmful policy of the Trump administration by actually looking at the risks that dangerous chemicals pose to fence line communities, to people who live right up next to the facilities. Dr. Friedhoff, when done as required by TSCA, do fence line analysis help EPA better protect vulnerable communities by more fully accounting for how those communities get exposed to dangerous chemicals?
Thanks very much, Senator, and absolutely. I toured a number of those communities and visited with them in Houston, and it was just unbelievable to be standing in the middle of a playground and seeing 10 smokestacks literally on the other side of the road. So unquestionably, there are some communities that are more exposed to more chemicals than others. And unquestionably, even though TSCA requires us to look at one chemical at a time, the fact is that you sometimes breathe more than one chemical at a time, and you sometimes drink water that has more than one chemical in it as well. And so what we've been doing is trying to create the scientific toolbox, so to speak, that will let us really understand those risks, the risks from more than one chemical, the risks from exposure through both the air and the water to the same chemical, and the different risks that some communities have compared to others.
Yeah, so thank you for that. And yeah, there was like a cloud over my ward growing up. And in fact, there was a union leader in my office last week, and we were talking about the Lewis Candy Company where I worked making gumdrops and jelly beans when I was 16, right on the Malden River. And he said, oh yeah, everyone knew there was like a huge black cloud over that building, which we didn't even think about because that's just the way it was, along the Malden River, just this big cloud, which today would be something that obviously families would be concerned about, young people being exposed to. And Dr. Friedhoff, what would you say to those that TSCA isn't an integral part of the EPA's ability to use science to keep the United States and workers clean and healthy? What would be your message to them?
There's people who say that TSCA is not supposed to be for protecting workers who might be exposed to chemicals inside facilities. There's people who say that TSCA shouldn't be about protecting people who in communities who breathe or are exposed to chemicals from breathing air or drinking water. And I kind of struggle to understand what TSCA is about. If it's not supposed to be about protecting the people who work with chemicals, and it's not supposed to be about the people who are exposed to those chemicals in their homes and communities, I think very clearly that's what it's about. And it's important for us to be writing rules that are implementable and don't prevent the reshoring of jobs in this country. But I really don't think you have to choose between jobs and safety. We can do both things, and I think we have to.
And I agree with you. I was a worker in one of those facilities. And so absolutely historic work that you're doing, and clearly within the full intent, the penumbra of what the law intended. It's to protect people from these dangerous chemicals, and you are doing an historically great job in accomplishing that goal. So thank you, and thank you, Mr. Chairman.
Thank you, Senator Mark, very, very, very much. Dr. Friedhoff, is there anything you haven't been asked? You've never been asked a lot of questions here today, but anything you might like to have the opportunity, just to very, very briefly highlight before we close?
Honestly, all I'd say is that I really value the bipartisan engagement on EPW. It was integral to getting the law passed in the first place. EPW was really the center of all of those years of work to get the law over the finish line, and I really do welcome and appreciate all of the ideas, all the constructive engagement, and all of the collaboration as we work to implement the pretty young law.
Good. Well, my colleagues have heard me say over and over again, bipartisan solutions are lasting solutions, and it took a hard-fought, difficult struggle to get us to the point where we actually could enact and the President can sign TSCA into law. Our thanks to you and all the staff folks who helped us in those days to get the ball in the end zone. It was my dad who used to say some of the hardest things to do were some of the things that are most worth doing. Passing TSCA was a hard thing to do. And it's not enough for us just to say, we're going to pass this bill, and that's that. We have a responsibility to make sure it's being implemented in the spirit that was intended. We need to make sure that the folks that are needed to help run these programs are well chosen, and they do a good job. We have to make sure that the funding is provided. In the case here, we have two major sources of funding. One is EPA has the opportunities to impose fees, and we have the obligation to provide reasonable appropriations and make sure they're being well utilized. I want to commend you. I talked to several of our colleagues who said that you've taken time to come and meet with them and talk with them and their staffs. That's I urge our witnesses to do more of that. I think it pays great benefits. Joe Biden, President Biden likes to say, "Oh, politics is personal. All diplomacy is personal." It always has been, and it continues to be that. The last thing I'd say, there's a shared responsibility in terms of oversight. We have a responsibility, certainly the House has that responsibility, and we need to work in a spirit of cooperation, collaboration with them and with the administration and other interested parties. We're getting the football playoff season here these days, and I'm a guy who pulls for the Eagles pretty regularly, but I'm a great Andy Reid fan. He used to coach the Eagles, but he used to say that it's not time to spike the football, and it's not time to spike the football on this front either. But thank you for joining us today. Thanks even more for your service to our nation, and our thanks to your family for sharing you with us for all of these years. We appreciate your dedication and your insight into some of the challenges that EPA is facing in implementation of this legislation. And I believe both you and the members of the committee are committed to addressing TSCA implementation challenges. We also have a shared interest in both protecting people from exposure to harmful chemicals and preserving our nation's ability to compete and bring innovative chemicals into the market. I'm an optimist by nature, and I'm optimistic that we can work together, continue to make progress, and with the right kind of leadership here on this side of the dais and on your side, I think we can continue to make progress. Before we adjourn, a little bit of housekeeping. I want to thank our staffs, your staff, and also the staffs of our committee. A lot of work went into preparation for this hearing, and I just want to say special thanks to everyone and to Senator Capito. Before we adjourn, some housekeeping. Senators will be allowed to submit written questions for the record through the close of business on Wednesday, February 7th, which is about 2 weeks from today. And we'll compile those questions. We'll send them to our witnesses who are going to be asked to respond by Wednesday, February 21st. And with that, it's a wrap. This hearing is adjourned. Thank you so much.